Hello, this is Sachin Sawant. I am an immigration lawyer registered with the OISC at level 3, Advocacy and Representation. So today in our Q&A series, I am going to answer the question regarding absences. What is the maximum number of absences allowed for indefinite leave to remain application, which you are filing on the basis of being spent 5 years in the UK on a spouse visa or a partner visa or a civil partner visa. So everything comes under a partner visa category. So under the 5 year route to settlement. So in the immigration rules, to begin with, there is no specific mention on the highest number of absences that could be allowed. So in theory, any number of absences would be acceptable. We do get this question asked many times by clients as to how many days can I spend outside the UK? Am I allowed to go outside the UK on the spouse visa or the partner visa? So just want to give some clarity around that. So mainly the focus of at the ILR stage of the caseworker would be the applicant and their partner have they lived together in the UK for the last 5 years. And then the exceptions would be if there is any good reason consistent with the intention to live together permanently in the UK. So, in summary, uh, when you apply for a partner visa from outside UK or you switch from another visa category to a partner visa from inside UK, the applicant, you are telling the home office that me and my partner permanently want to live in the UK. That is our intention. Remember that intention is at the point of application, at the point of extension as well, and even at the point of indefinite leave to remain. So at all the 3 points, that intention should be there in your mind and heart, and that's the reason you are applying for you are making that application either for the initial application, the extension, or the indefinite leave to remain, which is also called as settlement or permanent residence, and any period of time that they have not lived together. So the ideal scenario would be uh, the you apply for the spouse visa, come to the UK, live with the partner for the 2.5 years, apply for an extension at the end of it, then continue to live for the next 2.5 years. At the end of 60 months, that is 5 years, you have lived together, and then you apply for ILR. However, obviously there would be some absences. You would want to visit other countries with your partner by yourself, etc. So what the home office is looking at is, as per the immigration law, this is what they should be looking at. So there is a good reason consistent with your intention to live together permanently. So there is no fixed time period that they've said in any 12 months you cannot be out for more than 180 days or anything like that. So, but the intention to live together permanently and in the UK. So, for example, if one of the partners, either the applicant or the sponsor, for work related reasons, they are traveling outside, uh, for holidays, you'll be traveling, for any training, vocational training, etc., for studying. So, if there is a good reason whereby the spouse visa holder, the applicant, if he has traveled outside the UK, preferably with the sponsor, it can also be a case where the applicant himself is traveling outside UK, or even the sponsor. Sometimes I have dealt with a case where European national working. So now European nationals have also come under the purview of Appendix FM or partner visas. So yes, so someone working 2 days from Italy and the rest of the days from the UK. So those are similar cases like for work related reasons. So that may be a reason or explanation. So the main goal is both of you should have spent uh, most of your time in the UK. So if that is the converse is the case where both of you have spent most of the time overseas, then the caseworker may have a reason to doubt your intentions of living together permanently in the UK. So remember, the things to remember. What is important to remember is, one is living together. So this is number one. And this living together, where do they want you to live together? In the UK. plus permanently in the UK. So these are three essences of this particular statement: permanent. So, and the main thing at the top is intention. So, intention to live together in the UK permanently. That is what they are looking at every stage, especially at the ILR stage, when you file the indefinite leave to remain application. And so, if that is not the case, and most of the time has been spent overseas, either by the applicant or both of you or the sponsor, then they may doubt the intention of living together permanently in the UK. Exactly this. So, this is the whole thing taken together. But to counter that, they will look at the things as such as the reason for the travel. I have done several cases on these lines. One of the examples was where the couple were outside the UK in their home in the spouse visa holders, the applicant's home country, where her mother was severely ill. She has certain medical conditions. For 1 year, they were living there. In spite of that, we were able to produce all the hospital bills, etc., get a statement from them. We made all the representations addressing all the immigration rules, and they did get uh, such an absence excused, and successfully the ILR was approved. The other example I gave was of working. Sometimes people do work between Europe and the UK, 2 days here, 3 days there, or some other combination, some weeks here. So there is no minimum or maximum that they are saying. However, this is what they will look at: the reason for the travel. It can be work, holiday, training, sickness, any family bereavement, if someone in the family uh, has died, something like that, or length of absence. So if you have been absent for a 6 month period, or you have been absent for 3 days each every week, something like that. So all those things, length of the absence, whether both of you travel together, whether the applicant and sponsor both travel together. So yes, the relationship was existing, they were living together, and now the only thing is permanently intention of living permanently in the UK. Remember, all the intentions are on the date of applications. The intentions may change in future after the application, even after filing the application or before a decision. But if the ideally, as per the immigration rules, if the intention changes before a decision is made, then you would be obliged to inform that to the Home Office. So just wanted to clarify about on this point. If you have any questions, you can write on our immigration forum on our website. We'll put the link. If you need advice on your specific scenario, you can book a consultation. We will have the link below. Thirdly, please do like and subscribe, especially subscribe this channel, because we will be making such updates. Even your own question or someone else's question posted on the website or in the YouTube comments, we'll try to address as many as possible. Especially if you do subscribe, it helps others. So same, exactly, someone will be in exactly a similar situation as yours. If you do see it, you like it or subscribe it, then others, YouTube will, the system has the algorithms where it will throw this particular video to others who are in similar situations, who are trying to find some answers on Google or somewhere, and they will reach this video and get some clarity on their situation. Yes, it is daunting to deal with all these applications, etc., for individuals. We being immigration lawyers, yes, we regularly deal with Home Office on all these matters. Hence, yes, so this is the update. We'll keep on giving any updates. Again, do like, subscribe, follow us on various social media platforms. Thank you very much.